Hello friends, today we will complete the admission part of Indian Evidence Act. In the last episode, I discussed section 18 and 19. Today I will start from section 20. Admissions by persons expressly referred to by party to the suit. Say in a suit, there are two parties. Party number X and party number Y. X referred a matter expressly to Z for Z's opinion. So whether the opinion of the Z in this case will be treated as admission or not. Statements made by persons to whom a party to the suit has expressly referred for information in reference to any matter in dispute are admissions. Again I am reading. Statements made by persons to whom a party to the suit has expressly referred for information in reference to a matter in dispute are admissions. It's very simple. See the illustration. The question is whether a horse sold by A to B is sound. A says, go and ask C. C knows all about it. A admitted that C, the person, knows all about the horse. Whether the horse is of sound or not, everything is within the knowledge of C. And A referred B to C for C's opinion, C's statement. Here, C's statement is an admission. I think it's very much clear for you. Now I am going to section 21. Proof of admissions against persons making them and by or on their behalf. Admissions, proof of admissions against persons making them. The person making the admission, that will be used against that person itself and by or on their behalf. Admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest except in the following cases. Number 1, an admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under section 32 of Indian Evidence Act. Number 2, an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body relevant or in issue made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. And number 3, an admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. I will discuss this section after reading the illustrations. Illustration A. The question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine, B that it is forged. A's claim that the deed is genuine, B is claiming that the deed is forged. Now, A may prove by a statement of B. A may prove the genuinity of the deed by a statement of B that the deed is genuine, and B may prove that the deed is forged by a statement made by A. A cannot prove by his statement, B cannot prove by his statement, but A can prove A's claim by a statement made by B, and B can prove B's claim by a statement made by A. But A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is forged. Number B. A. The captain of a ship is tried for casting her away. Evidence is given to show that the ship was taken out of her proper course, out of the regular route. A produces a book kept by him in the ordinary course of his business, showing observations alleged to have been taken by him from day to day and indicating that the ship was not taken out of her proper course. A used to maintain a book where he used to note day-to-day observation about the ship, about its position, about its route, about everything. And A produced that book to show that in that book it is mentioned that the ship is in her proper route. A may prove these statements because they would be admissible between third parties if he were dead under section 32 clause 2 of Indian Evidence Act. A is tried, A is the captain of a ship, is tried for casting her away. Here A is alive. If A were dead, the book A used to maintain on regular basis in the ordinary course of his business, where he used to note everything about the ship, its coordination, its position, its condition, everything. That book would be relevant if A were dead. That's why this book can be produced and can be taken into admission. Number C. A is accused of a crime committed by him at Calcutta. He produces a letter written by himself and dated at Lahore on that day and bearing the Lahore postmark on that day. Say A is tried for a crime took place in Calcutta, dated 1st January 2022. A showed a letter dated Lahore and A posted the letter from Lahore post office, and that letter with the envelope has the stamp, seal and date, everything of Lahore post office. Now A produces that letter before the court. What will happen? The statement in the date of the letter is admissible. The date that is mentioned on the letter is admissible. Why? Because if A were dead, it would be admissible under section 32 clause 2. At present A is alive, but if A were dead, this particular letter, date of the letter, date and place mentioned on the letter will be taken into consideration under section 32 clause 2. So, though A is alive, but that date and place mentioned in the letter will be taken into consideration and it will be admissible. Illustration D. A is accused of receiving stolen goods knowing them to be stolen. A received some stolen goods with the knowledge that those goods are stolen property. he offers to prove that he refused to sell them below their value. A may prove that these statements, though they are admissions, because they are explanatory of conduct influenced by the facts in issue. I am reading again. Listen it very minutely. A is accused of receiving stolen goods, knowing them to be stolen. He offers to prove that he refused to sell them below their value. One thing, he offers to prove that he refused to sell them below their value. If it is a stolen property, I can sell it at any price, because I got the property, I got the thing at free of cost, so I can sell it at any price. But if I purchased the goods by giving a price, say rupees 100, I will not sell, I will try not to sell the goods below rupees 100. That means the price by which I purchased the goods. A may prove these statements, though they are admissions, because they are explanatory of conduct influenced by facts in issue. This statement is an explanation to the facts in issue, whether A received stolen property or not. So, A may prove these statements, though they are admissions, because they are explanatory of conduct influenced by facts in issue. Number E. A is accused of fraudulently having in his possession counterfeit coin, which he knew to be counterfeit. I know a particular 100 rupees note is a counterfeit currency, and with that knowledge I kept it in my pocket. Fine. He offers to prove that he asked a skillful person. C is a skillful person who can identify fake currency, counterfeit currency. He offered to prove that he asked a skillful person to examine the coin, as he doubted whether it was counterfeit or not, and that person did examine it and told him it was genuine. I had the doubt in my mind. I had the knowledge. I have doubt that the particular 100 rupees note is a fake currency. I kept it in my pocket. And thereafter I met C, who is an expert to identify fake currency. I told him to examine that particular currency and to tell me whether it is counterfeit or not. C examined the currency and confirmed me that it is not a counterfeit currency. A may prove these facts for the reasons stated in the last preceding illustration. Last preceding illustration means illustration D. A may prove these statements, though they are admission, because they are explanatory of conduct influenced by the facts in issue. Now I am going back to the text of the section. Now it will be very much clear to all of you. Admissions are relevant and may be proved as against the person who makes them or his representative in interest. Person or his representative. But they cannot be proved by or on behalf of the person who makes them or by his representative in interest, except in the following cases. So this first part of the section has relation with the illustration A. What is illustration A? The question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine and B that it is forged. A may prove a statement by B that the deed is genuine, and B may prove by a statement of A that the deed is forged. Now come to the section, but they cannot be proved by or on behalf of the person who makes it. I cannot prove my statement or by his representative interest, except the following cases. So this first part of the section is explained in illustration A. Sorry. Now I am coming to subsection 1. An admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under section 32. It has relation. It is explained in illustration B. A. The captain of a ship is tried for her casting away. Evidence is given to show that the ship was taken out of her proper course. Now, A. The captain of the ship produces a book kept by him in ordinary course of business, showing observations recorded in that book that and indicating that the ship was not taken out of her proper course. He used to write his day-to-day activities about the ship on that particular book, and there is nothing mentioned, there is no observation in that particular book that the ship has been taken away from her regular route. This particular statement, A may prove these statements because they would be admissible. This statement would become admissible between third parties if he were dead. He means A, the captain of the ship, were dead under section 32 clause 2. So subsection 1 is clear. Now coming to subsection 2. An admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body or relevant or in issue made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. Rendering its falsehood improbable. Illustration. C and D. Now I am coming to subsection 3. An admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. An admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. The last illustration. Illustration E. So we discussed today two sections, 20 and 21. Regarding 21, section 21, I want to say a few things you may note which may help you for your examination purposes, either LLB or judicial service. Admissions cannot be proved by or on behalf of the person who makes them or by his representative in interest, except when it is of such a nature that if the person making it were dead, would be relevant as between third persons under section 32. This is one feature of section 21. Another feature, when it consists of a statement of the existence of any state of mind or body made at or about the time when such state of mind or body existed and is accompanied by conduct rendering its falsehood improbable. And number C, the last feature, when it is relevant otherwise than an admission. These are the three features of section 21. Now I am coming to the last section of the admission part, that is section 23. Sorry, I missed the section 22. Now I am coming to section 22. When oral admissions as to the contents of documents are relevant. Oral admission, my statement about a content of a document is relevant. It's very easy. Oral admissions as to the contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of such document under the rules hereinafter contained, or unless the genuineness of a document produced is in question. So it is very simple. It can be explained in one line, that the contents of a document which is capable of being produced must be proved by that document itself and not by parole evidence. A particular document, I want to prove the contents of the document. For that purpose, I have to produce the document itself, unless and until I am entitled to give secondary evidence in respect of that document. We will study about secondary evidence in the later part of this discussion of evidence. Now the last section of admission part is section 23. Sorry, I'm sorry. There is section 22A. When oral admission as to the contents of electronic records are relevant. The 22 is oral admission of the contents of any document, instrument, paper document. Now 22A, which has been inserted in the year 2000, is when oral admission as to the contents of electronic records are relevant. When oral admissions as to the content of electronic records are not relevant unless the genuineness of the electronic record produced is in question. The contents of any electronic record should be will become relevant unless and until the genuineness of the electronic record is produced. How to prove the genuineness of an electronic record? We will discuss it in later episodes of discussion on evidence. But till then, learn it that oral admissions as to the contents of the electronic records are not relevant unless and until the genuineness of that electronic record is produced. Now I am coming to section 23, which is the last section of admission. Admissions in civil cases when relevant. In civil cases, no admission is relevant if it is made either upon express condition that evidence of it is not to be given, or under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Let us understand the first part. In civil cases, no admission is relevant if it is made either upon an express condition that evidence of it extremely sorry. If it is made either upon an express condition that evidence of it is not to be given, the parties agreed that evidence of a particular thing will not be given, or under circumstances from which the court can infer, court can understand, court can assume that parties agreed thereto that evidence of it should not be given. One explanation is there. Nothing in this section shall be taken to exempt any barrister, pleader, attorney or vakil from giving evidence of any matter of which he may be compelled to give evidence under section 26. Under section 126. Under section 126 there are some provisions for the lawyers, vakils, barristers, etc. And this section will not operate as a bar in the operation of section 126. So explanation part is clear. Let me explain the first part of this section. This section lays down that in civil cases an admission is not relevant when it is made. Number 1, upon an express condition that evidence of it is not to be given, or under circumstances from which the court can infer that parties agreed together that evidence of it should not be given. The section gives effect to the maxim. The section has been enacted based upon a maxim. What is that? Interes re publicia ut sut finis liem. Means it is for the interest of the state that there should be an end of litigation. Based on this maxim, this section 22 has been enacted. So I think up to section 23 I am able to explain you, and you could understand my explanation. I will be very happy to get emails from you if you have any doubts or any query. From my next session I will start from confession, which is another very important part and very important for the criminal practitioners mainly. Till then, goodbye, stay safe. Thank you.